All right, so I've got a topic that I don't generally like very much, but it's something that happens and we need to discuss it. What do you do when your tenant leaves and has totally destroyed your property? Let's get started. Well, right from the start, you got to consider what you can and can't do in your situation. Everybody's situation is a little different, so we're going to talk about the things you should consider right from the beginning. Any funds that you have on deposit, that's your first consideration. The funds on deposit can go to repair and remedy damages caused by the tenant. Now, you want to make sure that you can attribute these damages directly to the tenant. To do this properly, you probably have to lay a pretty good foundation of what the condition of the premises was before they ever took possession. Now, once you've made the determination that all the damages that are present on the property were in fact caused by the tenant, and so the repair is a responsibility of the tenant, the next consideration after you've made all valid deductions to your security deposit and given notice to the tenant of those deductions, as well as any overages that you can calculate within the first 30 days after they've surrendered, you really got to consider the following. Does it make sense to sue the tenant to recover for these damages? Now, part of you is thinking, of course it makes sense. I'm going to sue the pants off of them. Well, they don't all wear the same kind of pants, and reaching those pants might be more complicated than you think. Here's a few things for you to consider first. Number one, if you won a judgment for $100,000 in total damages caused to you by your tenant, is there any reasonable expectation that you'll be able to collect that from your tenant? Even if you had 10, even if you had 20 years. There are some tenants who in 10 or 20 years will never have enough money to pay off a $100,000 debt. There are others who could pay it off quite quickly, or who own more than $100,000 in assets that you could potentially seize. And so in this situation, it makes more sense to go after those tenants, the tenants with assets that can be seized, than the tenants who don't really have any assets and likely will not have the kind of money required to pay off your judgment. Now, your judgment may be nowhere near $100,000. But if even 10 or 20,000 is way more than that tenant is able to pay, you might just consider forgetting the whole idea of suing that tenant. It doesn't make sense to go after someone from whom you could never collect. So that's also a consideration you have to take pretty seriously. Let's say that you've determined that the amount of damage is an amount that you could very reasonably collect from your previous tenant. The next thing to consider is, can you find them? Do you know where they currently live or work so that you can personally serve them, not you yourself, but so that they can be served by either a private process server or a constable with notice of that lawsuit? In order for your lawsuit to really take any kind of effect, you have to serve the defendant. That means you have to give them notice, generally speaking, in their hand, proper notice in person, so that they are aware of your demands in that lawsuit. If you're unable to do this, your lawsuit really doesn't get off the ground. And without this initial first step, the service of process, you really don't have the ability to get a judgment, and the whole purpose of your lawsuit is to get a judgment that you can actually execute. Without getting service of process, it's just not going to happen. Landlords, if you're getting value out of today's video, I would really appreciate you clicking that like button. That helps us out tremendously. Also, if you haven't subscribed yet, please consider subscribing. Any questions and comments that you leave down below, I will personally review to give you a quick answer. When it comes to filing a lawsuit, is what is it going to cost you? In terms of time, in terms of money? Is this something that you are willing to undertake really all the way to the end? Because it doesn't make sense to get started in some process that you just are going to tire out of midway through. A lawsuit, even in a small claims court, could take 6 to 9 months. In a county or district court, it could take a year or longer. Some lawsuits go on for multiple years. And if that's the case for you, do you have, number one, the stamina to make it all the way through to the end? And then the funding. What's it going to cost if your lawsuit does go on for several months or even a year or longer? That's a serious conversation you're going to want to have with any partners that you're involved with, and definitely with any legal counsel that you have. The fact that you're riled up and ready to go and can pay that initial retainer may not be enough to carry you all the way through to judgment. Make sure you have a frank conversation about what a full-length trial could entail and what you can reasonably expect based on the kind of case you will be presenting to the court. So let's say you've had all of those considerations and you've gotten positive answers, things that you check yes, yes, and yes to. Great. You can determine the damages, you can locate the defendant, and you are prepared for litigation. The next thing is, which court do you choose? I talked about the small claims court, I talked about the county court, and even the district court. So my recommendation would be to choose between the small claims court and the county court in your county. And the reason why is because these courts are the most familiar with landlord-tenant law. They're the ones that handle evictions. And because of that, they're the ones the most likely to be well-versed when it comes to landlord-tenant leases. And what you're arguing is something they've heard 1,000 times before. It's going to be much easier for you to lay out a well-set case. That's not to say that you couldn't get a good result out of a district court. I'm just saying that district courts get less exposure to landlord-tenant law, whereas the justice courts and the county courts in the state of Texas really get the lion's share of it. Most landlord-tenant matters are resolved in these two courts. So how do you choose between them? Well, the Justice of the Peace has a limitation in terms of its jurisdiction up to $20,000 worth of damage. So one thing that I tell prospective litigants is if your damages are already at about $15,000 or $16,000, once you include attorney's fees, you start getting close to that $20,000 limit. And the truth is, once you hit it, you either have to waive your attorney's fees, or if your damages exceed $20,000, the court doesn't even have jurisdiction to hear it. So once you get to $15,000 to $16,000 in damages, again, this is before attorney fees, before court costs. If you're at this point, I would suggest just bump it up to the county court, because that jurisdiction is much higher. And because of that, you're going to be better off in the event that your damages actually exceed the jurisdiction of the lower court. You don't have to worry about having to transfer or having to refile and starting the whole process over. Additionally, you also sidestep the automatic appeal that the tenant would get if they lose and simply want to have the matter heard again in front of the county court. It would be tragic to go all the way through one process just to have to go through it again. That's likely going to double your costs and the time and your aggravation in the process. So if you're at or around $15,000, just start the process in the county court, both for jurisdictional reasons and for procedural reasons, avoiding that automatic appeal, and put yourself in the county court. Now, anything below $15,000 might be worth the time and effort that it would take to get through the justice court. And the truth is, your tenant may or may not contest the matter, and you may win your lawsuit strictly on default. But you should always be prepared, again, to litigate the matter to its fullest extent. Where you go is probably a good conversation for you to have with any legal counsel that you have, but you can take these strategies that I've described if you're doing things on your own to decide. If I'm already at 15, maybe a good idea just to bump it up to the county court and start there. If you're looking for even more content on this channel, check us out on Instagram, follow us on TikTok, or join our Facebook group, Texas Landlords. Now, for building a strong case, you have to consider at what point you need to gather evidence. Now, I already discussed part of this earlier, but really you're gathering evidence for this case before that tenant ever gets keys. Before you hand the keys over to any new tenant, make sure that you have properly documented the condition of the property. That's both with photographs and video. Make sure also that you're able to establish that this is a condition that the tenant got the property in, and that throughout the tenancy you address certain issues having to do with repairs or maintenance, and that you can prove these with receipts and additional photographs. Every time you go in for an inspection, if you have photographs that you've taken to document the condition of the property during the tenancy, all of this is helpful. So that if you're just getting the property back after the tenant has left, yes, you can document everything there, but without something against which to compare the current condition to the prior condition, it's going to be difficult for you to establish for the court what that change exactly was. However, good documentation before, during, and after sets a good foundation of evidence that the court can review to definitively determine what things were likely caused by this tenant. Now, naturally, once the tenant has surrendered the property and you can go in and examine the damage that it's caused, you'll want to again take video and photographic evidence of these conditions. And one really quick and easy way of dealing with these things is to send a demand letter to your tenant saying, look, you've caused these damages. Please pay X, which is your estimate for the repairs, and we can resolve this matter between ourselves without the need to go to court. And some tenants will respond appropriately, and after you can figure out what the total cost of repairs is, you guys can work things out. But not every tenant will. So once you've determined exactly what damages were caused by the tenant and you've given them an opportunity to correct those damages, if they simply have not, or you and the tenant simply cannot reach amicable terms, your next step is the lawsuit. So your final piece of evidence is either A, estimates that you've gathered from repair people who you've had come in to assess the damage and what it would take to get it back to the condition that you had the property in at the time the tenancy began. Now, I'm going to tell you this is probably the weakest evidence and typically the worst way for you to manage your property. The best evidence is the proof of the payment that you made to get everything restored, because you're going to demonstrate to the court that you have actual damages, not estimated damages, but these are the things you actually paid. Secondly, you're going to restore the property to its condition, to the exact place where it was before the tenancy began, so that for your next tenant, not only you'll have a properly documented set of evidence showing what that condition now is, but you're showing the court, I have paid for these things. These things have been repaired, and that repair was necessary because of the damage caused by the tenant. You don't want to re-let the property in the damaged condition that the prior tenant left it in and let the new tenant know, well, you know, it's not my fault. The old tenant did this. You're definitely going to want to do whatever repairs are necessary in order to rehabilitate the property for the new tenant, both A, to set a benchmark as to the condition, but B, to deliver a top quality product to your new tenants. Don't put them in a damaged property when you have every capacity to rehabilitate the property and then move forward with a property in really good condition. So when it comes to preventing this kind of situation, what are some of the steps that you can take? Well, the first is you can go through a thorough application process. You can talk to a prospective tenant's current landlord, but the trick is to talk to the prior landlord. If they are currently renting from someone, that landlord may have an unspoken desire to get rid of this tenant as quickly as possible. And so they'd have an incentive to be less than truthful with you. And so if you're asking, well, how do they leave the property? In what condition have they left the property? How good are these tenants to you? What is your communication like? Yada, yada, yada. That landlord may be incentivized to give you bad information in order to get rid of that tenant fast. Whereas the prior landlord has no incentive to lie. In fact, that prior landlord is going to be the most honest with you because they've already gotten rid of a bad tenant, and they'll tell you point blank the exact problems that they had with them, unless they're subject to some kind of non-disclosure agreement from a settlement or something. And if they tell you, well, I'm limited in what I can tell you, that's code for we had to resolve things because there was a lawsuit. Things that you can research and things that you can determine are red flags for your incoming prospective tenant. So always go not just to the immediate landlord, but to the prior landlord for the best information available against this tenant. Finding out beforehand that a tenant doesn't treat property well is the best way to prevent them from mistreating your property. And finally, I think the best mechanism for maintaining your property in a state of constant repair so that it doesn't fall into disrepair is to be on the property often. If you have a tenancy that is 12 months long, you should be on that property at least twice, after 3 months and after 9 months. If you watched any number of my videos, you'll hear me say often about the 3 and the 9. Your routine inspection is the best defense for you in order to protect your most valuable asset, that rental property. If you are not conducting routine inspections, again, at least twice every 12-month lease term, you're just not entering the property enough times. It doesn't make sense to only enter at the beginning and then back again at the end of a tenancy. You should be on the property at least 2 other times to document the condition and be prepared if you begin to see problems erupting, to address those problems in a way that effectively stops any additional damage. It is extremely upsetting to have clients come into the office and talk about how a tenant completely destroyed a property. But what's even more upsetting is to later find out that really all of that destruction could have been either prevented or it could have been lessened to an enormous degree if the landlord had simply stepped onto the property early enough during the tenancy to get rid of a tenant who is just flat out bad for the property. If you have complicated tenants and are continuing in your journey to learn more and more about landlording, YouTube seems to think that this particular video is perfect for you. Watch it and all the other content that we have for you. And until next time, landlords, happy leasing.